Welcome to another edition of Question and Answer with a Criminal Defense Attorney. I'm Mark Solomon, a defense attorney in Denver, Colorado, and today's question is a follow-up on Speedy trial. But before we get to the question, don't forget to click like and subscribe with a little bell next to it to be notified of future videos. Now, today's question is from a viewer asking to explain CRS 181405 6GI, saying that this is the rule that the judge just cited had used to extend Speedy, he said violate, but to extend Speedy trial so that key witnesses could go to Mexico on vacation. Well, let's look at the statute. When you look at the statute of Speedy trial, it's 181405, as the viewer has said. And when we look at that, let's scroll down to G. I've highlighted 6GI, and the actual rule is that the delay not exceeding 6 months resulting from a continuance granted at the request of the prosecuting attorney without consent of the defendant if the continuance is granted because of the unavailability of evidence material to the state's case when the prosecuting attorney has exercised due diligence to obtain such evidence and there is reasonable grounds to believe that this evidence will be available at a later date. So let's apply this law to the fact pattern in our question. So can Speedy trial, which is normally 6 months in a state case, can it be extended for up to 6 months here without the consent of the defendant? The answer is yes, if the prosecuting attorney asks for it, which apparently he did. And let's go through this section I, which the question asks about part by part. Unavailability of the evidence. Witness went to Mexico. So obviously the evidence of the testimony is not available. Is it material to the state's case? If they can't win without it, if they can't go forward without it because they couldn't win without it, that makes it material. Did the prosecuting attorney exercise due diligence to obtain such evidence? Well, here in Colorado, that can be done in a couple different ways. The gold standard is to issue the witness a subpoena. If the subpoena has been served on the witness and then the witness is leaving the country, then the prosecutor has exercised due diligence. And is there reasonable grounds to believe that the evidence will be available at a later date? At the later date, meaning, is this person moving to Mexico or are they coming back? And in this case, the viewer stated that the witness is going to Mexico on vacation. So I think we can assume that that material witness would be coming back. So the answer to this viewer's question is, unfortunately, I'm sorry, that looks like it falls within that exception, and the judge could do it. So that is the question and answer for today. If you have a question you'd like to submit of your own, you can always email it to me, put it in the comments below, or tag me on Twitter. And as always, you have a right to remain silent. If a police officer asks you questions about what you have, what you know, or anything, you have a right to say, I don't want to talk to you. And if he persists, I want a lawyer.